Hi, everyone. I'm Tom Carpenter, and thanks so much for making time out of your busy Monday. I know it's the first real work day of the new year, and I'm grateful that you've all taken the time to spend part of your day here with us talking about about legal stuff, which is not always the most interesting thing. If you have questions during this webinar, you can feel free to put them into the chat. Uh, and by the chat, I mean if you're watching on YouTube or Facebook or LinkedIn, you can type a comment in the comment section, and it should show up as a question. And if somebody doesn't mind doing that, just so I can see from my dashboard that it's working. If anybody's out there watching this, feel free to type something into one of the comments, and I'll know that you can hear me and see me and all of that. So, oh, I see Nine Muses Travel. I know that's Danielle. Oh, and everybody else. Okay, hi Jessica, hi Garrett, hi everybody. Perfect. So, this is our end of year law update. I've got a bunch of stuff that I want to talk about, so I'm just going to get right into it. This is my information where you can find me if you need to get in touch with me. My law firm, my email address, my mailing address, which don't show up at my office because I'm rarely, if ever, there. A few professional responsibility disclosures to get out of the way. This could be viewed as attorney advertising. This might be viewed as attorney advertising for the states where I'm licensed to practice. This is intended to be for informational purposes only. We are not intending to provide specific legal advice about any one particular topic, and prior outcomes don't guarantee future results. So just because something was decided one way in the past year doesn't mean that's going to be the decision that that a court would reach the next time around. By participating in this session, we're not creating an attorney-client relationship unless I already represent you. And we will talk a little bit about some things related to business structure. So we're not tax attorneys, though, and nothing in this presentation should be viewed as tax advice. I'm going to mostly skip over this because I feel like if you found your way to me, you probably know a little bit about who we are. But suffice it to say that we're a law firm. Most of our clients are in the travel and tourism industry. We have clients in the travel industry all across the country and pretty much all 50 states, I think, at this point. Most of our clients are small travel agencies and tour operators. In addition to our law practice, though, I happen to own a small travel business myself, so I do the same sorts of things that you all do. Wanted to talk a little bit about just kind of laying the groundwork for where we are in the industry right now. There is still strong demand for travel in 2026. The last year was a little bit volatile, but the luxury market in particular is showing strength in spite of a certain amount of economic uncertainty. Overall, because of the strength of the luxury market, travel spending grew, not by leaps and bounds, but it did grow modestly in the last year. But inbound travel to the US is down substantially, quite substantially. The backdrop of all of this, there are new and challenging geopolitical tensions. We'll talk about those a little bit. There is an economic downturn that we're in the middle of, and tariffs have increased costs for this across the supply chain, and have created a certain amount of additional inflation. I'm not trying to be political about this, but the bottom line is tariffs are increasing costs for people. Future of travel, there are a few themes that we're seeing. Ongoing geopolitical tension, fragmentation, the increased use of AI is presenting some challenges, which we'll talk about a little bit later, and costs are going up particularly for suppliers in the industry because of persistent labor shortages. Let's talk about what's been going on. When I started this, putting together the deck for this presentation, the U.S.-Venezuela conflict was a much smaller scope. And then yesterday, everything got a lot more complicated. So prior to the events of yesterday, or events of this past weekend, rather, um, there was still an ongoing effect on U.S. Caribbean travel. I personally was on a cruise, and the cruise right before my sailing was supposed to stop in Trinidad and Tobago. They canceled that port of call. There were some commercial airlines that had some issues, run-ins, near misses with military aircraft in the area. So there was already some effect to the U.S. and Caribbean U.S. travelers who were traveling in the Caribbean. But with the military operation over the weekend, most of you probably know that pretty much shut down travel in the entire region. Travelers were stranded in Puerto Rico because their flights couldn't take off. So that has become a lot more complicated. I posted something on my Facebook page yesterday about how to respond to those questions. My understanding is things are slowly getting better. Airlines are increasing their capacity to get people home. Cruise itineraries are being reconfigured so that people can actually sail. But we're not really sure how long this is going to last. But that's a long way of saying that geopolitical tensions are very real. They are affecting travel in a very serious way. Also, the Israel-Gaza conflict affected travel to the Mideast. Travelers were even countries and destinations that weren't involved. Travel to Egypt was down, for example. The Russian-Ukraine conflict, which has been going on for a couple of years now, has made the airspace over Eastern Europe off limits for a lot of airlines, which means they're having to take longer routes and burn more fuel when their normal flight pattern would go over those areas. There are some potential conflicts in Asia, in the Taiwan Strait and the South China Sea. Those have been on the verge of escalating for quite some time, which impacts travel to that region. Border tensions with Mexico. All of this is increasing security costs for corporate travel, for suppliers, leading to flight disruptions. Fuel costs are increasing, and consumer confidence is a little bit shaky. So be aware of that because that seems to be continuing in 2026. I want to spend a little bit of time talking about legal and regulatory developments that have that we were dealing with in 2025. The big one, in my view, is the Airline Consumer Protection Rule. So a couple of years ago, there was this rule that was really good for consumers that basically said that if you are if you have a flight that's substantially delayed or canceled and you can't be reaccommodated, that the airlines were required to give you a refund, a mandatory refund promptly within a reasonable time period, within a certain number of days. That rule would have required travel agencies to give refunds if you were the merchant of record on a transaction. That's not most travel agencies, but if you do a lot of groups and you've got an airline contract and you're on a GDS and issuing tickets, that might have impacted you. ASTA was doing some really good work around trying to close that loophole so that agencies wouldn't be in the position of having to give a refund if they were the merchant of record when the airline wasn't refunding them promptly. Basically, travel agencies, small businesses should not be acting as bankers that are giving loans to big airlines for refunds that are obligated under DOT rules. Airlines, so the Trump administration has reversed this rule entirely. Which is actually kind of bad for consumers. It's what the airlines were asking for. They no longer have to offer these refunds. It eliminates the concern about the travel agency loophole. Airlines do still have some refund obligations independent of the rule, but generally speaking, this is kind of bad for consumers. There were a lot of things in that rule that ASTA was actually lobbying for and in favor of, and we're happy to have those things in. That one little minor thing about travel agencies having to give refunds if they were the merchant of record, that was a small small minor fix, but we're kind of back to square one with airline refunds. There are some new entry requirements that have been expanded for key destinations and a few other changes. The United Kingdom introduced a ETA visa. So if you were from a visa-exempt country early last year, there was a pre-travel authorization step, very similar to the US ESTA program. There was a slight change after that was implemented. It used to apply to people who were transiting through Heathrow, for example. They closed that up. So if you're in transit, you no longer have to apply for the electronic travel authorization. In the EU, they have another visa authorization that moved toward implementation. The one thing I would say about these two new visa requirements, and this is not necessarily a legal thing, but taking off my legal hat and putting on my travel, I don't actually wear hats, but putting on my travel advisor hat, so to speak. I think a lot of times travel advisors, because they want to seem relevant to their clients and they want their clients to know that I'm on top of this, they spend a lot of time talking about, hey, there's this new thing that you need to be aware of, and you're going to have to do these things in order to travel to the UK and the EU. I personally have a view that that creates, in a situation where we're already dealing with some spotty consumer confidence, I feel like marketing your services based on the fact that you're aware of a new visa requirement is kind of a double-edged sword, to the extent that it might actually prevent somebody from picking up the phone and calling you because they think, oh, there's this new thing, it's going to be more complicated to travel, I'm just not going to deal with it, forget that, I'm staying home. So just think about how you're marketing that, because these are not big things, they're not difficult, you can do it online, it's super easy. And so don't make your clients scared to travel by talking about these things, because they really are quite easy to deal with. There's also stricter visa vetting for inbound travelers at US border crossings. That has made some people, especially if people have immigration petitions that are in process, concerned about traveling. And then the other thing to be aware of is one of the first executive orders that the new administration put in place was to eliminate the X gender marker. So if you have clients who are transgender, gender nonconforming, non-binary, intersex, and if they were using the X gender marker, you may want to have a conversation with them, because obviously your travel documentations need to match, your travel documentation, your passport, your visa, your driver's license needs to match what's on the reservation. And if you have clients who are concerned about traveling because they have an X gender marker on their passport, I'd recommend having a conversation with them so that they can do what they need to do in order to feel comfortable traveling. Real ID was implemented. I love this picture. Look at these two. They're so happy to have their new IDs because they're going to go on a trip. So as starting in the beginning of May, adult travelers needed to get Real ID. After kicking the can down the road for years and years and years, it finally came to pass that now you need this. People weren't really, it didn't really disrupt travel early on, but in 2026, there are going to be some new fines and penalties for non-compliance rolling out. And so if people were skating by without having a Real ID in 2025, they're probably not going to be able to do that much longer. A couple of other small additional DOT rules to be aware of. There were some regulations related to wheelchair users. If you have clients who travel by air and use wheelchairs, it basically governed training of airline employees so that they could properly accommodate travelers who have disabilities that and wheelchair users. Also covering damage to equipment, which is a real problem for wheelchair users, the airlines damaging their equipment when transporting it. And it actually put in some enforcement mechanisms in place. There's also a DOT rule about ancillary fees. This would be fees for baggage, seat assignments, Wi-Fi, requiring more transparency around what those fees are. And of course, there are refunds that are owed if you select your seat and then you don't get your seat, or it's broken, or the Wi-Fi doesn't work and you paid for it, all of those types of things. So just be aware of those things if you've got a client who has questions about the seat assignment that they paid for but didn't get, be aware that there are some DOT rules there. Happy to help talk to you about those things if you like. The Federal Trade Commission put in place a quote-unquote junk fee rule. There are also similar rules in California, but in May of this past year, there are now rules governing offering, displaying, or advertising prices for live event tickets. Some of you may sell those as a booking agent if you do event travel, and lodging, including hotel stays. Which are now requiring that the full total price has to be disclosed, including any mandatory fees, and those have to be disclosed right up front. You have to ensure that the total price is the most prominent price that's displayed, and if there are any fees that are excluded, that are legally excluded, you have to disclose those before you get payment. And so this is primarily an issue for people who are selling a la carte hotels. There is no safe harbor for travel agencies that pass along bad pricing. So if you're getting pricing from your supplier, just double check it and make sure that the supplier has included all of the mandatory fees that are in there. Taxes are not fees, so keep that in mind too. And there's also a bill that's been advanced in Congress called the Hotel Fees Transparency Act of 2025. I haven't looked at that recently, except I know it's out there, so that might be happening. Beneficial ownership information. So last year at this time, we were talking to people about doing a BOI filing with the federal government. The Corporate Transparency Act is a law that's designed to prevent money laundering and other financial crimes. It was passed to figure out, like, if somebody owns an LLC that's incorporated in the United States or a corporation in the US, if it's a foreign owner, we should be able to know that so that we can prevent money laundering. Well, there were a bunch of lawsuits about invasions of privacy, all this stuff. And shortly after the law was implemented, enforcement was scaled back substantially to the point where most people don't really need to file these things any longer. If it is a foreign-owned entity, they may still have some compliance obligations. But if you've already filed your BOI information filing, the information you filed is likely going to be deleted to address some of the privacy concerns that, as part of the new administration has taken those steps. If you are doing business in New York, if you have a New York State LLC or corporation, there is a parallel law in New York that took effect on January 1st, which is the New York State Corporate Transparency Law. It has a narrower scope than what was initially enacted, partially as a result of what went on in the federal lawsuit. There may be other state laws on the horizon that kind of replicate the BOI filing. So if you are a company in New York State and you have questions about what you need to do to comply with this law, feel free to reach out to us. We're happy to talk to you about it. But also, I would say what we were saying about the federal law holds true with this New York law. Beware of scams, because there are lots of companies out there that were using this law or these required filings to sending you information saying, hey, fill out this form so that we can file it for you. They were taking a lot of personal information and stealing identity, committing identity theft and stealing your personal information. So if you are filing anything and this goes with any government agency for any purpose whatsoever, make sure you're actually on the official government site. If you really feel like you need help doing that, and we're representing your business, reach out to us, because I promise you we won't scam you. We have an attorney-client relationship and are subject to professional responsibility regulations, so we're not going to scam you. But if you have some random email that comes through your website offering to do these compliance things for you, check with us if we represent you, and we're happy to help with that. which is a great segue into the next section. I want to talk about AI and especially how AI intersects with fraud. So travel advisors are using AI increasingly for all sorts of purposes. And I have some of these are legal concerns, some of these are not, but just be careful about how you're using AI, because there was a case involving Air Canada where their AI chatbot gave passengers false information about airline refund policies. And even though the AI bot, like, I don't know what data set they were drawing from, but they gave the wrong information, and there was a lawsuit, and the courts held that, yes, you are liable for incorrect and bad information that AI gives you if you pass that along, or if AI presents it directly to your consumer, your client, through a chatbot. So you're liable for that inaccurate information. So if you're using it and passing it along, double check it, triple check it. I'll also think about whether or not increased use of AI is actually degrading your skill set as a travel professional, because the more you're using AI to do your work for you, you just might want to give some thought to whether or not that makes you a little bit less sharp when you're doing work to protect your clients. And whether it undermines your value proposition. So as a travel advisor, when I work as a travel advisor, my goal is to take care of my clients before, during, and after their trip. My clients come to me because I invest in my relationships with suppliers. I really want to know my stuff. And if you're just using AI and repurposing that information for your clients, you're really not providing the expertise, taking advantage of the training and the years that you've put into your business to grow it and build it. But there are also some data privacy and security concerns related to using AI. If you are putting your client's personal information into AI to get a result, that information is going into a data set that might be used to generate other responses to other people based on your client's personal information. So just be careful in all of these different ways that you're using AI. One way that AI is, well, I want to talk a little bit about scams, and some of these are AI related or have some sort of intersection with AI. I'm seeing a lot of last minute request scams where a new client will call you up looking for an expensive trip on short notice. The way they do this, they use a stolen card, and they're hoping to either use the ticket before they're caught, or they're going to exchange a refundable ticket for cash in some developing country where people can do that. What I'm seeing now is that scammers are making seemingly legitimate, low value bookings first. So what they do is they'll call you up and they say, hey, I just need a hotel at the Courtyard Marriott by the airport for one night. Can you book that for me? You think, you know what, that's like free money. Of course I can do that. It doesn't cost very much. You're not worried about it. So you make the booking, even though it's short turnaround. And then when they check in online, but they're using a stolen credit card. Once you've made that first booking for them and they've established a relationship of trust, that's when they call you and say, oh, and by the way, I also want to go to Bali in 2 weeks. Can you book that for me? Once they've lured you in and you have that relationship, they're banking that you're going to be a lot more comfortable booking that big Bali trip. And that's where you get the chargeback that you wind up having to pay for a much more expensive trip. So my recommendation is that be on the lookout for these things. Requests for premium international or multi-stop itineraries where the client doesn't seem to be sensitive to price. People who are asking to pay with multiple credit cards or cards in the name of somebody other than the traveler. If they're reluctant to complete your client intake form or verify the identity, especially if they're booking non-refundable ticket requests, or they're requesting travel that originates outside of the US, my recommendation would be to say no to all of these. Just say no, because these are all red flags for scams. And this is where AI comes in, because it used to be that, you get that request from a Nigerian prince that wants you to help them get money, and they're going to give you a cut of that. Well, that's how they found the stupid people who would fall for those things. You're all running businesses and you're not stupid people. So they've exhausted their supply of people who are going to fall for the Nigerian prince scam. And now what they're doing is they're using AI to sound legitimate. They are using AI to generate and impersonate voice calls, video avatars that could look very realistic. They're mocking up credit cards and passports so that they look legit. And so you can't rely on, that doesn't look right, because it might look right, it might sound right. And so my recommendation would be just decline all last minute bookings, period, full stop. And think about it this way: somebody who wants you to book a really expensive airline ticket for them at the last minute, and they found your small business on the internet, and they're willing to go through, sign your client agreement and do all this stuff so that you can make that booking for them. If they can find you on the internet, they can also book an airline ticket for themselves, especially a really expensive non-refundable airline ticket, on their own. They don't need you to do that. So just say no. Phishing scams are on the rise. There are all sorts of fraudulent emails, or if you don't know what phishing is, fraudulent emails are websites that are designed to trick you into revealing your personal information so that they can steal your identity. It's not just making fraudulent bookings. They're actually trying to get into your bank account, your email, your credit card accounts. People are using AI to make these sound legitimate. I just want to give you an example of something that happened to me in my travel agency. So here is an email. You might want to search your own email boxes to see if you got anything like this. An invitation to go on a podcast. Hey, Thomas, just following up on my invitation from earlier. Let me know if this is something you'd be interested in. And I scroll down, and apparently this person allegedly reached out to me a couple of weeks earlier about being on their podcast called The Top 3 Mistakes That Ruin Direct Bookings in the Face of Rising Ad Costs. Now, I mean, I don't think I'm stupid, but I don't know what that means. But the person, whoever this improbably named Nicolina Cristo is, she wants me to be on a podcast. Well, I'm a small business owner, so of course I want to be on a podcast. That's like free advertising. So I would normally be inclined to respond to this. There are no links in here for me to click. She's not asking me for any information, just to reply to her email. So I did a little bit of investigation. Turns out that that there's a LinkedIn profile. Caitlin, who supposedly found me on LinkedIn, isn't attached to that company. It just didn't seem legit. Well, look at this. A couple weeks later, a couple weeks later, in my law practice, I got something saying, hey, our colleague Caltrin, another weird name. Apologies if anybody on here is named Caltrin. I didn't mean to disparage you. I should have thought before I said that. But they wanted to do a podcast featuring me, and the wording was almost exactly the same. So what they do is they try to draw you in by appealing to your desire to get free advertising, maybe your vanity. I've gotten some lately saying, hey, we want to write a book about your life because you've got a really interesting life story. What they do is they go back and forth with you a little bit. You send 2 or 3 emails. They send you a link. Maybe looks like a Calendly link to set up an appointment. Maybe it's a Zoom link to log into their Zoom for a video call. And it's a phishing email. It's a phishing link. And they use that to start to hack your system. And that's how they get all of their information. So here's one that I got in my travel business. Ho Thomas, which I resent that. Thank you for your quick response. This was after somebody reached out to me as an Astra referral. Actually, people have gotten these from Virtuoso referrals as well, from other referrals. Somebody wanted to plan a trip, and you can read this and see how eager this guy is to send me his Zoom link. I offered to meet with him by Google Meet. I offered to do a phone call. No. He only wants to meet with Zoom, and he's going to send me the link. This has been happening to a lot of people lately. It is a fake Zoom link, and they're trying to get you to give them your password so that they can hack you and steal your identity. Wanted to talk a little bit, and this is happening all over the place. Um, Phishing attacks are especially bad with respect to wire transfers. So be really careful when you're wiring money to suppliers, because a lot of suppliers are now providing discounts, like Viking, for example. You can save some money if your client pays by wire transfer instead of using a credit card. They're trying to avoid chargebacks, which I totally get. But if you're expecting if your email has been hacked and the hackers know that you're expecting instructions for a wire transfer, it's very easy for them to send you wire transfer instructions that are going to put that money in their account rather than the supplier's account. And if you send your client's money to the wrong account, it is almost impossible to get it back. So, pro tip, what I would recommend if you are wiring money to a supplier, start with a very small test transfer. When you get the wire transfer instructions, start with a transfer of $100, something small, where if you lose it, it's not going to destroy your business. Once you do that $100 transfer, call the supplier directly. Don't call the number on the wire transfer fraud email. Call the number that you have for the supplier that's in your Rolodex that you use all the time when you're calling them. Call that number, confirm that it was received, and follow up with an email, not responding to the email that you were sent with the wire transfer instructions. Start a new email and send it to your person to confirm that it was received. And then once you get confirmation that that $100 went through, then you can put forward the payment for the balance of $50,000 or whatever. I hope you've got a $50,000 booking. But that's the way I would recommend doing it, so that you don't wind up getting scammed. And then, of course, there's the chargeback fraud, where a client books a trip. This is not AI. This is, some people call this friendly fraud. The client books a trip and they use the credit card dispute process to try to avoid paying for what they booked with you. I think a lot of times clients think that they're getting their money back from the credit card company, like it's some sort of satisfaction guarantee. But really what they're doing is they're reporting their charge as a fraudulent charge. So if you use their credit card to charge back, to make that charge with your supplier, it's kind of like they're accusing you of credit card fraud. And there are scenarios where that could come out of your pocket. So just make sure you've got the right language in your terms and conditions to protect against that. And also that you're using the magic language for credit card authorizations that the credit card companies require, because you're going to want to get a proper authorization for every charge. Talked about that in other webinars. If you don't know what I'm talking about, shoot me an email and I'm happy to help talk about it. Okay, we're okay on time. I'm burning through this, but there are a few areas of heightened risk that people are increasingly asking about. And so I just want to flag these things for you, because especially with so many new people entering the industry, a lot of people come up with an idea, they think it's really great, and they fall in love with it, and they don't realize until they've started to implement it that there are actually some real problems with that. One of them is acting as a tour operator. And if you've tried to get your E&O policy through Berkshire Hathaway, they may have asked you a bunch of questions and then told you that you're a tour operator. And some of you are like, well, I'm not a tour operator. Well, this is the test that they were using. I'm not going to go over this in detail, but Berkshire Hathaway had this list of things that, in their view, made you a tour operator and meant that you needed a more expensive policy. But here's the thing. What Berkshire Hathaway considers to be a tour operator is not what a judge or a court would say is a tour operator. But if you're with Berkshire Hathaway and they tell you you need a tour operator policy and you want to stay with them, that's the policy you should put in place. But be aware that other carriers aren't using that same definition. You might want to get a quote from one of those if you're thinking about making a switch. So what is a tour operator? There's a big gray area there. If you are traveling with a group, that is the least tour operator-like thing you can do. If you do come with me trips, that's maybe a pinky toe into the tour operator lane. You can still do that and still be a booking agent. That shouldn't be a problem. If you're taking net rates and marking it up, that starts to make you look more like a tour operator, because you're probably going to be the merchant of record on that transaction. Some agencies do that and never have a problem. We can put things in your terms and conditions document to make sure that your clients are agreeing that they understand that even if you're handling client funds, that you are not a that you are not a tour operator, you are still the booking agent. If you're a hosted advisor, your host agency contract probably prohibits you from taking net rates and marking it up and handling client funds. Bundling things together, that's also a little bit tour operator like. But the number one thing, and this is the case Van Rossum v. Penny Travel, if you white label a trip and you don't disclose who the real supplier is, then you become the supplier. And the reason that's a problem is because if you are the tour operator, you are going to be responsible for giving a refund to your clients in many cases, even if the supplier is not refunding you. You're going to have increased liability for damages, injury, or loss when your clients are traveling. If the supplier goes bankrupt and you've sold the trip and white labeled it, you are on the hook for delivering what you sold. And you also might not be able to use your host agency's seller of travel registration, or you might need to get your own, because if you're handling direct payments and handling funds, that will take you out of the exemption from having your own. So this is definitely a no-go for hosted businesses, but that's one reason why you really need to disclose the supplier. So if you don't want to be the tour operator, you got to disclose who your supplier is. If your terms and conditions, and I hope they do, contain a provision requiring your clients to agree to the supplier terms, the good news is you don't have to have them separately agree to your supplier terms if you've incorporated that into your own terms and conditions. But your clients might not understand what your role is as the booking agent. So in your terms and conditions, you really want to make that clear, that they're agreeing that they understand your role as the booking agent and not the supplier. But you also might want to disclose that on an invoice, etc. I've had a bunch of inquiries lately. I haven't heard about this in a while, but lately it's come up more than a few times. So I wanted to talk a little bit about surprise travel, where people hire you to book a trip. And they say, we don't care where we go. Here are our dates. Here's how much money we want to spend. Where are you going to send us? That sounds really, really, well, it might sound fun to you. To me, it sounds like a nightmare. But like, I would not want to take that trip. But surprise travel carries a lot of risk if you're booking that, because one of the key things in your terms and conditions document, you're shifting the responsibility to your clients so that they are taking responsibility for making sure that they're comfortable traveling to the destinations on their itinerary, that they are comfortable with the suppliers that you have put in front of them and that you're booking for them. And so you can't shift that responsibility to your clients if you're not disclosing the supplier or even the destination of where they're going. And so your terms and conditions are just not going to protect you in that case. I just have a strong view that if you are at all serious about booking, about protecting your business from legal risk, I would not do these surprise trips. But if you do want to do it, and that is like going to be the key thrust to your business, I would call your insurance carrier, insure yourself to the hilt, because I think that's what you're going to need. I'm getting a lot of inquiries from people who are building, especially new businesses, and they are intending to book residents of other countries. I think you might want to rethink that, because some suppliers, especially a lot of cruise lines, may not allow you to book non-US residents. If you have a host agency, your host agency's contract with suppliers might not support bookings from non-US agencies, and your clients might be required to pay in US dollars rather than whatever their local currency is. And if their currency uses the dollar sign, like whether it's Canadian dollars, Australian dollars, or Mexican pesos, where the dollar sign is there, if they think they're paying one price and it actually shows up on their credit card statement as something else, that could be a problem for you. But the big thing is that when you book residents of other countries, you are subjecting yourself to the laws and the regulations of those countries. And in the UK and the EU, there are these laws called the Package Travel Directive and Linked Travel Arrangements. Those are significant, serious, and heavy regulations that you're going to have to comply with. And you might be surprised at what your liability is. I'll just tell you that I was attending a conference of the International Forum of Travel and Tourism Advocates. That's the International Travel Lawyers Group, of which our firm is a part. a part of that group. And one of our friends from France was talking about a case where a travel agency booked a French citizen, French resident rather, on a cruise. The traveler slipped at the buffet on a piece of cooked fennel that fell off the buffet, slipped, broke her femur, and then sued everybody and anybody, including the agency that booked the cruise. Now, obviously, that travel agent was not on the cruise, and it wasn't their responsibility to clean up the floor around the salad bar. But the French court found that just because the travel agency sold that trip to a French resident, that they were liable for the broken femur. And that was appealed. Appeal was upheld. So if you don't want to be liable for people slipping on cooked fennel, sell in the US because we can protect you from that. In Brazil, you have to have a physical office in Brazil. In Canada, Canadian courts may require you to defend a lawsuit in Canada rather than recognizing the language in your contract about, or your terms and conditions about choice of law. So, I mean, think about your business model, whether you really want to take on the responsibility of complying with all those regulations, because as much as we have to deal with in the US, you have to deal with a lot more in other countries. Okay, independent contractors. This is, I saved the biggest for, I don't know if this is the last. I think this is almost the last. So there are a ton of legal issues related to independent contractors and relationships between agencies and their ICs. Those issues exploded in 2025, and I don't think we're done with it yet. So here's where we are. There are at least 3 lawsuits currently pending against travel agencies related to IC issues. In Massachusetts, there's a class action lawsuit alleging that the agency exerted improper control, quote unquote, over their ICs. That lawsuit survived a motion to dismiss. My understanding is that it's resulted in exorbitant settlement demands, which it probably won't settle for that much, but still, there are a lot of legal fees that attach to defending those types of things. In Indiana, there are a couple of lawsuits against an agency that was trying to enforce a non-compete clause against independent contractors, which, in case you haven't heard me scream to the rafters about this, you can't enforce a non-compete clause against an independent contractor because they are independent, but some people don't care about that. Florida lawsuit, there's a Florida lawsuit which has been pretty high profile, and unless you've been under a rock, you probably know that there is an agency in Florida that terminated a bunch of their ICs and is withholding all of the commissions. And so there are lawsuits about that. At the same time, there's also a lot of pushback from independent contractors over contract terms that are really reasonable and appropriate provisions. So some of those high profile incidents and the bad behavior from agency owners has led a bunch of ICs to question the terms that are in their IC agreement, even when those terms are proper and legitimate. And there's some really bad information circulating online and social media groups about what constitutes control and what doesn't. And so there are lots of people taking that advice and getting really worked up about it and starting fights. So here's what the law is, and it's a little bit complicated. So there are different legal tests for independent contractor classification. If you, in the IRS has a right of control agency test for tax purposes, which the principal question there is how much control does the agency exert over a contractor? At the Department of Labor, it's a different question. It's the economic realities test. And the question there is how integral is the work of the IC to the agency's business? So if you're a travel agency and you have ICs, that's a tough one to win because your ICs are selling travel, and selling travel is what a travel agency does. And then there's state law, which every state has a different IC test. I've got the California flag there because those of you who were around before the pandemic probably remember all of the things we were talking about AB5 and the ABC test. That same test is used in some states like New Jersey and New York, but every state interprets it a little bit differently. The bottom line is you've got 3 different tests for what an IC, what could make an IC legitimate. And they are not necessarily consistent with each other. So like the IRS could determine that you are properly an independent contractor for purposes of tax withholding, but the Department of Labor might decide that you owe minimum wage and overtime, and the state of New Jersey might decide that you should have been paying unemployment and workers' comp for your remote employees who are ICs in that state, or your remote ICs in that state who should have been employees. That's all. That's just a lot of stuff. It is not a bright line test. If somebody is out there telling you they can't tell you to do this, this, and this because that makes you an employee or that's improper for an IC, it's a totality of the circumstances. That having been said, there are a lot of things like exclusivity, non-compete clauses that are a big thumb on the scale, that I would never recommend an agency putting those things in place. But if somebody's telling you they can't give you an email address or they can't ask you to meet with them, those things are probably not going to be things that are going to jeopardize IC status. This is why it's important to get it right. There are civil penalties. There are criminal penalties in some cases. There was an agency owner in Minnesota who went to jail because they were committing wire fraud by stealing from their ICs a couple of years ago. The Department of Justice put that guy behind bars. And there are state law penalties in addition to it. So you really want to have a tight independent contractor agreement if you're using ICs. There's a lot of confusion around different types of ICs. So hosted businesses are independent contractor relationships. If you are with a host agency, your whole business is an independent contractor of your host agency. That would be if you're running your own business, if you're independently branded, you are probably, if you are running your own hosted business, if you're running your own independently branded business, you're probably better off being with a large host agency that can actually support you running an independent business. Generally, the splits are higher for independent contractors that are hosted by a host agency and running their own business. You need to get your own errors and omissions. You need to have your own terms and conditions. Even if your host agency provides E&O insurance, you should get your own. If you're an IC sub-agent, you're not running your own business. You're just selling travel. So you're selling under the brand name of another agency, selling under their nameplate, their branding. That is legitimate for independent contractors. There's somebody out there on social media telling people they can't tell you have to use their branding. Well, there's nothing improper about an agency owner saying, I don't want to host independent businesses. I only want to work with people who are selling travel under my agency name. That is a legitimate IC relationship. You're still independent, but you're not running your own business. Generally, the splits aren't usually as generous if you don't have all the expenses of running a business. Here are the problems, though. People who bring on virtual assistants or who hire team leaders as ICs, maybe if you structure it as a B2B relationship where they're running their own business and providing those virtual assistant services for other businesses, maybe that can be structured in a way that's not problematic. But if you're giving them work direction, if you're paying them an hourly rate, you should probably just go ahead and make them an employee. Because if you're quote unquote training people or you're giving work direction, or even worse, if you're paying somebody else to give your other ICs work direction, those things start to get a little bit messy. So be careful about that. So just a few things for agency owners: don't steal their commission. Don't cut people off unnecessarily. Don't try to make it difficult for your ICs to move on. If somebody has outgrown your agency and they want to move on, as long as they're not stealing your stuff, come up with a transition plan, make sure they get paid properly, and let them move on. Make sure that you take a good look at your IC agreement. The first thing that's going to happen if you get audited or if somebody marches into a lawyer's office with a copy of their contract, they're going to look at the contract. And if there are things in there that are problematic, that's going to come back to bite you in circumstances like that. And don't treat your independent contractors like employees. If you want to boss them around, make them an employee, hire a payroll service. It's a little bit more expensive, but it's not that difficult to run payroll. And if you are an independent contractor, don't steal stuff from your agency owner. Don't steal their documents and their policies and their client lists. Don't poach their other ICs to have them follow you out the door because you're mad at the agency owner. Don't cancel bookings, divert bookings. Don't take leads from your agency that they've given you and book those with another agency. And don't think that you can create unlimited liability for the agency that you're working under without actually being responsible for that, because there are probably some indemnification provisions that are legitimate and will hold up in your IC agreement. If you run up a bunch of debit memos or chargebacks or lawsuits or threats of lawsuits, you're going to be responsible for those things. And your agency shouldn't be left holding the bag for that. And also, just don't believe everything you read on the internet about what being an IC means legitimately. So I'm just about done here. In 2026, here's what I'm recommending that you look at. If you are a Virtuoso agency or if you're hosted by Virtuoso, they have a new membership agreement. There's some things in there like productivity requirements, a requirement that you have a data security and data privacy policy. There's some exclusivity requirements in there. And so if you are hosted by a Virtuoso host agency, they may be revising their hosting or their IC agreements. And that is to comply with the Virtuoso membership requirements. I've drafted those for a couple of my clients who are Virtuoso host agencies. There's nothing nefarious in there. It's really just designed to square everything and reconcile it with the Virtuoso membership agreement. And also keep in mind things like productivity requirements and exclusivity requirements that might be problematic. If the host agency was imposing those are not requirements imposed by the host agency. Those are requirements imposed by the consortium. It's a very different thing. And if you have questions about that, happy to talk to you about it. If you don't already have these in your business, you need a good solid terms and conditions document. You want to get out in front of your clients if you're going to have disputes with them. But also, you can't really win a chargeback dispute if you don't have a terms and conditions document. So if you don't have something in place that's airtight, I would strongly recommend that people have something that is custom for their business. Every business is different. There are a lot of things that I see in those cookie cutter documents that people are either selling or renting to people that I think are problematic. If you want to send us what you're using now, we're happy to take a look at it and tell you what we think, because also you don't need to spend money to fix something if it's not broken. Website terms of use and data privacy policies. Up until recently, we have been telling people, if you're a small business, you might not need these, because those data privacy laws that are out there really only apply to businesses that are doing like $25 million in sales or more to California residents. And like, I mean, I wish, right? That's not my business. Maybe it's not yours. Maybe it is yours. If it is yours, you should have a policy. But there's just so much scrutiny now about data privacy. And a lot of people have blogs on their website that might require having an advertising disclosure policy. Those are not very expensive to put together. We do them. It's like maybe a half an hour of billable time when we do them. So less than a couple $100. My crushingly awesome associate Brandon does those for people. If you haven't met him yet, he's the best. Don't ever quit, Brandon. Strong, tight, independent contractor agreements. You should really have those in place too if you're working with ICs. And all the stuff that I said before about IC relationships, it's super complicated. There are problems on both sides. You really want a tight contract if you're an agency owner that's working with ICs. Group contracts, lots of people are moving into groups, especially when, I should have said, aside from luxury travel being up, group travel is actually pretty lucrative these days, and destination weddings, MICE travel, People have complicated groups. If you've got like a Pied Piper who's putting the group together for you, you're going to want to have the right kind of contracts for those things. So you should put those in place. So for current client, so that's for everybody out there. But for our current clients, if you're currently a client of our practice, just wanted to let you know that our insurance does require us to disengage from representation if we haven't done anything for you in a while. So if you get a letter from us saying we are sending you this letter of disengagement, it doesn't mean that we don't love you, because we do. We'll still keep you on our list for updates if we've done your terms and conditions, but we may be sending those letters out just so that our insurance, so that we're square with our insurance. But again, if we've done your terms and conditions document, we include you on our mailing list. So if we update our boilerplate on any particular thing, we don't send you invoices with that. We won't send you invoices with that. But even with all of the changes that we saw in 2025, we're not actually recommending significant updates to your terms and conditions for 2026. But if something has changed on your end and you're not sure whether you're covered, if you've cultivated a new niche or something like that, reach out to us and we're happy to talk about it. Our hourly rates are not going to increase in 2026. We are implementing a small increase in our flat rate packages that we do for terms and conditions and for setting up LLCs and corporations, which we also do on a flat rate in all 50 states. Our costs have increased on that in a little bit, and we're including some additional things to make up for that. Anyway, call me if you have a question about that. We are definitely recommending that people shore up their data privacy policies, as I mentioned in the earlier slide. I think we've moved from those being nice to haves to borderline must-haves. So if you don't have a data privacy policy or a website terms of use or an advertising disclosure policy, call us and we're happy to help put that together for you. And we're recommending that even if you're working with ICs, and even if you've never had a problem up to now, we think it makes sense to take a look at your IC contracts to make sure that they're showed up, just in light of all the litigation that's out there. So stay on top of all those changes, and more importantly, stay tuned for future webinars, because we've got a lot of things that are on our YouTube channel. And some of those are a couple of years old. And so we're going to be kind of revising and revisiting those and re-recording those. And so we'll put notice on our Facebook page in advance to make sure that we are, giving you the most current information on our page. So I'm going to, oops, let me see here. What am I doing? This is what happens when you're your own technical director as well. That's where you can find me if you need to. So I've been looking at, hi, Georgia. That's an inside joke between me and Josh. I'm taking a quick look at some of the comments and the questions, and I'm going to take these as we go. Let me just change the frame here. Okay, so hey, Sharon. So Sharon asks, can you elaborate about the training and what that means? I think that might relate back to independent contractor agreements. And so basically, training is a buzzword for employment. And so if you are, quote unquote, training your ICs, that could be something that might be a problem for you. So I would just generally recommend not doing that. And Sharon, if I've gotten that wrong, type something in the comments. If I'm not misunderstanding what you're asking for. Nice to see you, by the way. Let me know. BOI, if you don't have foreign interests, you don't have to file. If you don't, at this point, if you don't have a New York, yeah, so I would say if you don't have any foreign ownership, you probably don't have to file. Give us a call if you have a question about that, and we can try to, I'm going to change the framing because that kind of looks weird. We can talk to you about the specifics with respect to your business. Okay. Yeah, like with respect to BOI, the BOI filing is no longer required for most companies. If you have a question about whether it applies to you, call us and we'll help. Okay. Hi, Rebecca. Okay, if the client is doing the wire transfer themselves, would you suggest they do the same thing and you assist with the confirmation between them and the supplier? Uh, yes, I think it's a best practice to do the small transfer first, and feel free to share that with your clients if they're doing the transfer directly. It might be a little bit more work for you and calling back and forth to kind of facilitate those conversations. I definitely think it's probably a good idea. Um, okay, Karen. Hi, Karen. Just often suppliers offer to white label their product for you. Uh, I I would politely decline that. I mean, but even if they do white label it for you, I think you can still take advantage of that if it looks really good, if it's slick, if you like the way it presents itself to your clients. I think that's fine. But you want to make sure that you're at least disclosing who the supplier is, either on the invoice or if you have the ability to drop a footnote saying, this presentation was, this trip is being booked through, and then the name of your DMC or whoever it is. That's important. Um, okay. Uh, Patty is asking, what E&O carriers do I recommend? I do not recommend E&O carriers. I can tell you that the three main insurers that insure most of the industry are Berkshire Hathaway, Aon, which is capital A, capital O, capital N, and also Hiscox. For a while, Asta had a discount arrangement in place with Hiscox. I don't know if that's currently in place any longer, but if they were working with Asta, um, I think that's pretty good. I can tell you that another part of our practice, our entertainment practice, we put together offerings and for commercial theater productions, and we use Hiscox for to ensure those Broadway off Broadway productions. So Hiscox, Aon, Berkshire Hathaway, those are the big three. There may be others out there, but I would say get quotes from them. Look at the policy, especially look at the exclusions, because you might be surprised at um, what is excluded. Here's a good one. Thanks for mentioning this, Cynthia. ADA compliance. Yeah, we are. We have heard from a few clients who have gotten shakedown letters from uh, people saying your website is not ADA compliant. My client is visually impaired or hearing impaired or has whatever issue, and they can't use your website, and send us money or we're going to file a lawsuit. Well, a lot of those lawsuits have been filed. Most of them settle, but those are actually lawsuits that have been filed by, I think, like the same 2 or 3 law firms, and maybe even the same 3 or 4 plaintiffs have been filing those lawsuits, and almost all of them. But it's an issue, and so if you get one of those letters and we're representing your business, call us. We've dealt with that for our clients, and we're happy to take a look at it. Okay. I think those are all of the questions. Oh, wait, I'm scrolling down. Okay, so I think most of these. Oh, relating to the ADA training at the airport, Sharon says. Yeah, I don't have a lot of information about what airline employees are, what training exactly they're getting. I'd have to dig into the regulations for that, but it's not something that imposes an obligation on your agency. It's all about airline employees getting training about how to work with people who are wheelchair users at the airport. Okay. Providing education to ICs. This is a good question. Let me put this up here. Hi, Kelly. Gosh, like so many people, like I'm just like really happy to see so many friendly faces and names in this chat. And if I don't know you yet, feel free to introduce yourself. Okay, so So training is a buzzword for ICs, but a lot of the way you can get around that is by using your supplier resources, using resources like ASTA has some really good professional development programs. The Travel Institute has some really good programs. You can encourage your ICs to take part of those things. I will say there's a difference between orienting your ICs on processes and training them. A lot of people don't call it training just because it does sound like a buzzword. Things like mentoring, coaching, but providing them with training tools that are provided by third parties is a good idea. And then if they're just not doing those things, then I think at a certain point you're going to want to say to them, hey, I strongly recommend that you do these things. And if they don't do it, then at a certain point you have to kind of figure out, do you really want to be working with those people? Oh, here we go. Subagents incorporating as LLCs for added protection. So if your independent contractor has a limited liability corporation, you're going to want to have very specific language in your IC agreement requiring a personal guarantee. And what that means is that if your IC, you don't want your ICs who are incorporated as an LLC to run up a bunch of debt under your umbrella, a bunch of debit memos and chargebacks and recalled commission, and then they bankrupt their LLC entity, and the LLC entity protects their personal assets from liabilities of their LLC business activity. So if you've contracted with their LLC, they run up a bunch of problems for you, and then they bankrupt their LLC, then you're left to pay for all of that. And that's going to be a problem. So what I would recommend is putting language in there. I've had ICs who push back on that because that sort of defeats the purpose of having an LLC if their personal assets aren't protected from liabilities of their business. But I would just encourage you to think about like whether you really want to bring somebody on. Like they can have an LLC and you can enter a contract with them as an individual, but you don't want to put yourself in a position where they're going to run your business into the ground and then bankrupt their own, and you wind up having to deal with the consequences. So, so that is work. Okay, Sarah. Hey, Sarah. Onboarding works for sure. That's a great suggestion, Summer. Thank you for that. And internal CRM and processes. Yeah, I mean, I think that's orientation. I wouldn't call it training. I mean, you're telling them what they need to do in order to get paid. It's it's basically, here's how we work. They're not going to be exclusive. They can go off on their own and do their own thing. They can book through another channel if they feel like they want to, but that's fine. Being an IC under a host and being an IC subagent, the difference there is really the branding, right? So are you running your own business, or are you just selling travel under somebody else's business, right? So if you are a hosted business, I'll just give you an example. So my business is Huckleberry Travel. We are hosted by Uniglobe. Shout out to my Uniglobe family if you're on the call. I love my host agency. They're great. My whole business, Huckleberry Travel, is an independent contractor of Uniglobe Travel Center. We have an IC agreement with Uniglobe, but we run our own business. We're responsible for everything we do. And we have independent contractors. So I own the business, and I have independent contractors who sell under the Huckleberry Travel brand. Those are sub-agent independent contractors. They are independent contractors of Huckleberry Travel. Huckleberry Travel is an independent contractor of Uniglobe. So my IC relationship with Uniglobe is a hosted business, and Aaron and Michelle and Natalie, who are independent contractors of Huckleberry Travel. They have no interest in running a business. All they want to do is sell travel. We have contracts with them that are independent contractor contracts. They sell travel. They don't want to take on all the responsibility of running their own businesses. And frankly, I don't want the responsibility of supporting somebody, one of my independent contractors. I don't want the responsibility of supporting them because I'm not a big agency. I'm not a host agency like Uniglobe. So that is basically the difference as I see it. I hope that's helpful. Those are both legitimate independent contractor relationships, though. All right, I have gone over. I hope that's okay with people, but I'm going to end the stream now. But again, I'm really grateful that you took the time to meet with us. Keep in mind, we're going to be doing more of these webinars in the future on different topics. We'll do deeper dives into business structure and documents and policies and things like that. But if you need us, you know where to find us. Don't hesitate to reach out. We are happy to help if we can. And best wishes to everyone for a healthy, happy, prosperous 2026. I hope you sell a lot of travel and make a ton of money. And if you need help from us, we're here for you. Thanks so much. Bye-bye.